Introduce today's presenter, Jennifer Damon, Director of Compliance and Chief Privacy Officer at AccuSource. Jennifer graduated from the University of Akron School of Law with a Doctor of Law JD degree and has over 10 years experience in the background screening industry. She is an experienced compliance professional with knowledge from both the employer and consumer reporting agency sides. She has performed various roles in the industry, including interpretation of criminal and civil records summaries, managing quality control, and managing the E-Verify program, including audits for a billion-dollar facility services company. She has experience with government clearances and contract review. Jennifer is responsible for AccuSource's compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees our quality assurance process. Now, I'll turn the presentation over to Jennifer.
Good morning and welcome to our year-end compliance webinar. We will be addressing numerous topics today and we'll be answering questions at the end of the presentation. Please send any questions you have and I will address as many of them as possible, or we'll follow up through email if we run out of time. First, let me ask this. How is it going to be 2022? I feel like 2020 just ended and we're now weeks away from a new year. 2021 was a whirlwind year and was up with other recent years. It brought changes to the background screening industry. We will start this presentation by highlighting some of those key changes. We will then go over some trends to watch as we enter 2022. Our review of 2021 will include updates on ban-the-box laws, a recap on identifier redaction in California and Michigan, an overview of new privacy laws, a discussion of the amendment recently made to the New York City Fair Chance Act, and a review of recent marijuana and drug screening related updates. We will then look forward to 2022 and discuss anticipated trends for the upcoming year, as well as provide best practice recommendations. As usual, before I begin my presentation, please keep in mind the following. The content provided in this presentation is for informational purposes only. It should not be construed as legal advice or serve as specific guidance. AccuSource strongly encourages current and prospective clients to seek the advice of qualified counsel, preferably specializing in employment law, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Please also keep in mind that this is a general discussion. I will not be covering specific state laws and exemptions. Generally, I will talk about them a little bit. For example, some employers may have some exemptions to general laws due to their industry or the type of position. It's best to discuss your specific business needs with legal counsel to ensure that you are compliant. Our discussion is also limited to criminal records. We will not be discussing credit reports, which are governed by federal law and are also restricted by certain state laws. First, we'll discuss fair chance legislation, also known as ban-the-box. Except for webinars that are focused on a specific area, we almost always have a ban-the-box update to share during our compliance webinars. Before I dive into the specifics, first I want to go over what banning the box actually involves. Ban-the-box laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, generally before a conditional job offer is made or before an interview is conducted. For example, an employer in a ban-the-box jurisdiction typically cannot include questions about criminal convictions on the initial job application. In other words, they are banned from including a checkbox asking if the applicant has been convicted. The goal of fair chance laws is to allow applicants with prior convictions to not only obtain an interview, but also advance to a certain stage in the hiring process before being asked about prior criminal history. Additionally, these laws may require that the background check process start later. A majority of the US population is impacted by ban-the-box laws, since about 3/4 of the US population lives in a state or local jurisdiction that has banned the box. These laws can span a variety of employers, including public, private, or both. Let's first discuss the Louisiana Fair Chance Law that went into effect since our mid-year webinar. House Bill 707 created a ban the box law under Louisiana's revised statutes. It became effective on August 1st of this year and affects an employer's obligations during its consideration of criminal records, and also restricts the records it can consider based on a case's status. An employer cannot request or consider an arrest record or charge that did not result in a conviction if it receives that information during a background check. When considering criminal records, an employer should conduct an individual assessment of whether a criminal record has a direct and adverse relationship with the specific duties of the job. That balancing test must be used to justify denying the position to the applicant. The assessment must also include a review of the nature and gravity of the offense or conduct, the time that has passed, and the nature of the position. Additionally, an employer must make available any background check information used during the hiring process if the applicant requests that information in writing. Over the summer, Maine passed a ban the box law, which became effective on October 18, 2021. The law, which is a standard ban the box law, prohibits an employer from requesting criminal record information on an initial employment application. An employer also cannot state in the initial employment application or advertisement that a person with a criminal history may not apply or will not be considered for a position. The law also prohibits an employer from otherwise stating that an applicant with criminal history will not be considered, at least before first determining whether that person is even qualified for the position. There are exceptions, including where federal or state law, regulation, or rule mandates that a criminal conviction disqualifies an applicant from a position, where it's required that an employer not hire an applicant who's been convicted of certain offenses, or where it requires that an employer conduct a criminal history record check. This one actually has some financial consequences to employers. An employer who violates the law must pay between $100 and $500 for the violation. I also want to review some of the ban the box laws that we've discussed throughout the year. I'll be focusing on laws that are likely to impact a greater number of organizations, such as statewide laws. However, remember that you can find information about more localized laws in our mid-year webinar and blog posts. Illinois amended its Human Rights Act, and SB 1480 became effective on March 23rd. It restricts the use of criminal records when making employment decisions. An employer cannot disqualify an individual based on a conviction until after it has determined that a substantial relationship exists between the conviction and the position, and has engaged in an interactive process with the individual. It is a civil rights violation for an employer to use criminal records to make an employment decision unless one of two exceptions applies. Under the substantial relationship exception, the job position must provide the opportunity for the same or a similar offense to occur, or involve similar circumstances that existed during the original offense that are likely to reoccur. Employers are required to consider 6 mitigating circumstances. 1, the length of time since the conviction. 2, the number of convictions on the individual's record. 3, the nature and severity of the conviction and its relationship to safety and security of others. 4, the facts or circumstances surrounding the conviction. 5, the age of the individual at the time of the conviction. And 6, evidence of rehabilitation efforts. A second exception exists where the hiring or retention of the individual would cause an unreasonable risk to property or the safety of others. The amendment requires an interactive assessment between the employer and the individual. If an employer plans to take adverse action, it must provide written notice of its preliminary decision, identifying the specific conviction or convictions that the employer feels meets one of the exceptions described previously. It must also provide a copy of the conviction history report and information regarding the individual's right to respond to the notice and to provide mitigating information before the decision becomes final. The employer must wait at least 5 business days between notices and must consider any information provided by the individual before it makes a final decision. If the employer decides to ultimately take adverse action, it must provide another notice explaining the basis for its decision, including the specific conviction or convictions that led to that decision. It must also provide any internal appeal procedures and the right to file a charge of discrimination with the Illinois Department of Human Rights. Arizona passed a second chance law in April. Effective on August 27th, House Bill 2067 allows courts to issue a certificate of second chance for individuals whose judgment of guilt is set aside after a criminal conviction for certain offenses. This certificate will allow individuals to apply for and obtain occupational licenses. It will also provide protections to employers who choose to hire those with the certificates, such as protection from negligent hiring and retention claims. However, employers are not required to consider the certificates or required to hire those who present them, and they can also still ask about prior convictions. The amendment also does not redact or remove any part of an individual's criminal record. Kentucky also created a certificate program, and HB 497 became effective in July. In order to obtain a certificate of employability, an incarcerated individual must complete vocational or educational training requirements and successfully maintain a crime-free record for a designated period of time before release. Exclusions do apply. For example, sex offenders cannot receive the certificates. Employers can request the certificate from a job seeker and verify that certificate with the Department of Corrections to ensure that it's valid. However, employers are not required to accept an applicant with a criminal record, but does receive protection from negligent hiring lawsuits if it does. Georgia's SB 288, which has been in effect for almost a year, gives some Georgia ex-offenders the chance to have certain convictions removed from their criminal records after a period of conviction-free years. For misdemeanor offenses, an individual can petition the court if it has been 4 years from sentence completion, no new convictions have occurred in those 4 years, and there are no pending charges. Certain offenses are excluded. SB 288 also includes negligent hiring and retention claim protections for employers who provide second chance hiring. Alabama passed the Redeemer Act, which became effective in July and allows for the expungement of misdemeanor and non-violent felony convictions. It does not include violent felonies or sexual offenses. It is also open to those who committed more serious offenses but later received a pardon. Those who would like expungement must petition the court, and judges will determine whether to grant the expungement based on factors such as the nature of the offense and how long ago it occurred. You may be wondering why I haven't discussed New York City's updated Fair Chance Act yet. This topic is so important that it has its own dedicated section in this webinar. More to come shortly on New York City. The availability of identifiers for criminal records has been a hot topic in the background screening industry in recent months. So important that AccuSource presented a dedicated webinar about it. However, in case you missed that webinar or our blog posts, I wanted to provide a quick overview of the issues and provide an update. In 2019, the Michigan Supreme Court adopted a rule to redact personal identifying information, or PII. Its rationale for the rule is to protect against identity theft. Under the law, the court must remove the date of birth from court records before providing them to the public. This results in a full redaction of date of birth from public view. One issue is that the Michigan State Court Administrator's Office has a broad interpretation of the rules, going beyond simple redaction. Michigan court clerks will not be permitted to verbally confirm the date of birth, which is an option used by background screening companies in some jurisdictions. They also will not be allowed to conduct a search by date of birth. These rules may also affect other identifiers, which could leave only an individual's name as the sole identifier available for background checks. This is especially problematic because the Consumer Financial Protection Bureau recently released an opinion that name match only records do not meet the FCRA's requirement of maximum possible accuracy. With this information, please keep in mind that if AccuSource receives a possible record that is name match only, we cannot report it or will be violating the FCRA. It's also important to note that ordering a full court file will no longer be helpful because the date of birth will still be redacted from that file before it's presented. The original implementation date for the redaction rule was July 1st. However, due to efforts by the Professional Background Screening Association, that implementation date was moved back to January 1st, 2022. I will have an update on that later. The Michigan SCAO had presented two options for background screeners to obtain identifiers. First, a court researcher can provide each applicant's consent to have his or her date of birth released to the researcher. However, does that consent need to be specific? Will a general authorization under the FCRA work? And really, how will clerks handle an influx of requests along with their usual duties? The second solution is that background screeners can obtain records through Michigan's iChat system, which is a statewide repository housed by the Michigan State Police. However, only serious offenses would be available through iChat, offenses where fingerprinting is required. Pending cases could also be missed if a defendant has not yet been fingerprinted. There are other issues with both proposed solutions, but as you can see, they are both problematic. At this time, I do have some updates to share today about Michigan's date of birth redaction rule. First, be aware that some courts may have started redaction early. However, the SCAO issued a memorandum to Michigan courts stating that they must follow rulemaking procedures at this time. So meaning that they're not supposed to be redacting date of birth before the implementation date. Also, the Michigan legislature proposed Bill HB 5368 that would prohibit the redaction of dates of birth from court records. Currently, the bill appears to be on pause due to action taken by SCAO. The PBSA has continued to work with the SCAO, and the SCAO recently forwarded a counter proposal to the PBSA. The proposal defines consent for purposes of background screening. Consent is generally required except for individuals who are authorized by the SCAO to have access to date of birth in order to verify identity. The proposal also sets up a registration process for authorized users. Upon registration and every 6 months, the user must provide assurance to the SCAO. Authorized users must also provide initial and annual proof of professional liability insurance. So we actually have a new update that just came into my email box last night after I'd already prepped the webinar. So let me just fill you in on our new exciting updates out of Michigan. The PBSA was very, very happy to report that the Michigan Supreme Court adopted the negotiated court rule on Michigan redaction. Pretty much what we just talked about, where authorized users can register in order to obtain identifiers. That should be going forward. and they're moving the effective date of these new procedures from January 1st to April 1st, 2022. Now, since this is a very new update, I'm definitely going to write a blog post about it, so I would definitely check that out, and I'll be able to provide more details in that, but there is very much hope in sight for Michigan. In addition to Michigan, we have also seen identifier issues out of California, which arose out of litigation based on the interpretation of a court rule. Under All of Us or None v. Hamrick, Riverside County Superior Court and Hamrick, who is its executive officer and clerk, were sued by parties representing the rights of formerly incarcerated individuals and convicts. The plaintiffs brought 7 causes of action, but we will focus on just one of the claims today. That cause of action stated that the court and its clerk violated California Rules of Court Rule 2.507. This rule specifies what information can be included in and what needs to be excluded from court calendars, indexes, and registers of actions. The list of excluded information includes date of birth and driver's license number. Specifically, the plaintiffs argued that the court violated the rule by allowing users of its electronic criminal case index to search by a defendant's known date of birth or driver's license number. I won't go into too many details about the activities at various court levels since this was discussed in some detail during a recent webinar. The trial court decision, which was helpful to background screening companies, was ultimately reversed on appeal. The California Court of Appeals 4th Appellate District held that Rule 2.507 prohibits California courts from allowing searches of its electronic criminal index by date of birth or driver's license number. It also stated that the text of the rule is not limited to the public disclosure of identifiers that is not otherwise known to the person using the index. The court also pointed out that the purpose of the rule is to protect the privacy of those involved in criminal proceedings. Ultimately, according to the appellate court, the ability to search by date of birth or driver's license number, even when that information is known to the user and provided by that specific individual, is considered a violation of Rule 2.507. PBSA once again stepped in. Along with the Consumer Data Industry Association, the PBSA submitted an amicus brief letter to the California Supreme Court on July 15th. The letter asked the California Supreme Court to review the Court of Appeals opinion. It also asked the court to consider the impact the decision will have on interested parties, such as background screening agencies, employers, and even those who give their consent for background screening. For example, criminal background checks in California will be delayed and may become impossible. Additionally, the PBSA pointed out that it will be difficult for background screening agencies to provide accurate results, even in industries where checks are required by law. Like with Michigan, the courts will become overwhelmed. Background screening companies will receive more results, especially for common names, and will need to obtain additional identifiers from the court. On September 1st, the California Supreme Court denied review, meaning that the decision still stands. As of today, we don't have any new updates out of California. While the PBSA is seeking alternate paths to resolving this issue, those paths aren't quick. How does this impact background screening? AccuSource may experience processing delays. Where we cannot rule out cases or obtain identifiers using online case searches, we will need to verify identifiers at the court. That process may have its own delays, as courts may be facing reduced staff, limited hours, and COVID-19 protocols. Additionally, some counties could pause background screening altogether as they address this new rule interpretation internally. Courts throughout the state will likely redact dates of birth and driver's license numbers from public access terminals and online court searches. Some clerks, such as those in Los Angeles County, may stop verifying dates of birth at all, even in person. The ability to search by date of birth or driver's license number online will also be impacted. We do want you to keep in mind that AccuSource can process clear records as normal. However, there could be delays or other difficulties associated with possible hits, especially if an applicant has a common name. As redaction in Michigan and California plays out, we will keep you updated, especially if we have any updates out of California. Privacy is always a hot topic in our industry, and we covered 2 new privacy laws in our mid-year, so I will touch on them briefly as a refresher. The Virginia Consumer Data Protection Act, or VCDPA, was signed into law on March 1st, 2021, and will be enforced starting January 1st, 2023. Companies may be covered by the VCDPA if they conduct business in Virginia or target Virginia residents with products or services. Like California, the VCDPA has thresholds for when businesses are covered. It must either control or process the personal data of at least 100,000 consumers during a calendar year, or control or process the personal data of at least 25,000 consumers and derive at least 50% of its gross revenue from personal data sale. The law does not include a revenue threshold requirement, which means that larger organizations can be exempt if they do not fall under one of the 2 thresholds. Because the definition of consumer excludes a person who is acting in a commercial or employment context, this means that VCDPA excludes employee data. It also only applies if the exchange of data is for monetary consideration. The VCDPA also excludes certain transfers of data from its definition of sale and also exempts 5 categories of entities. There are also 14 categories of exempted data sets, including data regulated by the Fair Credit Reporting Act, the Driver's Privacy Protection Act, and specific employee and job applicant data. The VCDPA includes various rights for Virginia residents and obligations for covered companies. We also covered the Colorado Privacy Act previously, so just a quick recap. In order to be subject to the CPA, a company must conduct business or produce products or services that are intentionally targeted to Colorado residents. Second, the company must either control or process the personal data of more than 100,000 consumers per calendar year, or derive revenue from the sale of personal data and control or process the personal data of at least 25,000 consumers. The CPA does not apply to personal data governed by delineated state and federal laws or employment records. The definition of consumer excludes those acting in a commercial or employment capacity, which means that job applicant and employee data is excluded from CPA. The CPA is very GDPR-esque. Consent is opt-in and requires a clear affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement. If you're familiar with GDPR, you know that that sounds pretty familiar. The CPA is scheduled to take effect on July 1st, 2023, but a cure period is provided through January 1st, 2025. Because the CPA has similarities to GDPR, we highly recommend that you review to determine if it impacts your organization, and if it does, begin preparations now if you haven't already started to do so. We have previously covered the New York City Fair Chance Act amendment, but because it's such an important topic, I wanted to cover it today as well. First, under the new amendment, in order to revoke a conditional offer or take adverse action against an employee based on a pending criminal charge, arrest, or accusation, the employer must conduct an individualized assessment based on 7 factors, which are very similar to those under New York Article 23A. An employer must consider whether the individual was 25 years old or younger, at the time of the offense and must consider any information regarding rehabilitation or good conduct. It must go a step further than before and solicit information that will be part of its analysis, such as facts and circumstances surrounding criminal convictions. After the assessment, the employer can withdraw the conditional offer if there is a direct relationship between the underlying conduct and the employment, or if there would be an unreasonable risk to property or safety of others. The employer must follow the standard FCA process, showing that there is either a direct relationship between the alleged or convicted crime and the position, or that employing the individual poses an unreasonable risk to property or people. The amendment also updated the FCA related to what employers can ask about. Employers can no longer inquire about non-pending arrests or criminal accusations, adjournments and contemplation of dismissal, youthful offender adjudications, or sealed offenses. They also cannot inquire about or deny employment based on violations and non-criminal offenses. This prohibition does not include motor vehicle records. The new bill also updates the FCA process related to convictions. Employers must now review the FCA factors and provide notice before taking adverse action for criminal convictions that arise during employment. The effective date for the FCA amendment was July 29, 2021, and just 2 weeks before that date, the NYC Commission on Human Rights issued guidance. The amendment ultimately requires a bifurcated or two-part screening process. Part of the reason is because of the very specific way that conditional offer of employment is defined under the FCA. A conditional offer can only be revoked based on criminal background check results, medical exam results, or other information the employer could not have reasonably known before the conditional offer was made. For that last possibility, the employer must show that it would not have made the offer regardless of the criminal background check results. The Commission also included motor vehicle record results as part of the criminal background check. This very specific definition means that a conditional offer cannot be revoked for any other reason. So, in practice, if an employer wants to deny employment for another reason, such as an employment verification result, it must do so before it makes a conditional offer. But what does this mean in practice? An employer must delay criminal screening until after a conditional offer of employment has been made. The amendment goes further, prohibiting an employer from asking about or considering criminal history until after it's assessed all other qualifications. Additionally, if an employer wants to deny employment for another reason, such as an employment verification result, it must do so before it makes that offer. The Commission also includes requirements for disclosures under the FCRA. An employer is prohibited from including words such as criminal or background check in the initial non-criminal screening disclosure. The Commission encourages employers to use language such as consumer report or investigative consumer report instead. This may force an employer to provide two separate disclosures, one for initial non-criminal screening and one for post-conditional offer screening. AccuSource has processes in place to help employers comply with their updated FCA obligations. If you have any questions about your program or how AccuSource can assist, please let us know. Our last topic for today will cover marijuana updates. As always seems the case, we have a number of jurisdictions that either legalize marijuana in some way or provided protections for those who use cannabis legally. How do these laws affect employers in those jurisdictions when it comes to their drug screening policies? In general, employers can still drug test in many of the jurisdictions that have legalized some form of marijuana use, but it's definitely not a clear-cut answer, and the line is becoming hazier. In November 2020, Montana voters approved recreational marijuana. This year, its governor signed legislation that will protect off-duty use of marijuana starting on January 1st, 2022. Importantly, the amendment updates existing law so that marijuana is considered a lawful product. How does this affect employers then? An employer cannot refuse to hire or discriminate against an employee due to his or her legal use of marijuana off premises during non-working hours. An employer is permitted to take action if the off-duty marijuana use affects an individual's ability to perform his or her job or affects the safety of others, if the use conflicts with the bona fide occupational qualification, where the employer, as part of a professional services contract, can limit the use of marijuana, the employer is a nonprofit that discourages use of marijuana by the general public, or where the employer believes its actions are permitted under a collective bargaining agreement. While marijuana use does have some limitations related to employment, employers still may find it difficult to take adverse action for positive marijuana test results in Montana. Puerto Rico has provided additional employment protections for those who use medicinal marijuana. Act number 15/2021, which became effective on July 29th of this year, amends previous Act number 42 of July 9, 2017, which is Puerto Rico's Medicinal Cannabis Act. The act was originally silent as to how the employment of medical marijuana users could be affected by their use. Act number 15/2021 provided clarifications to that gray area. Now, any employee who identifies him or herself as a registered and authorized medical cannabis patient will be a member of a protected class for employment protection law purposes. For employers, this means that they cannot discriminate against protected users during recruitment, hiring, termination, or with other employment conditions. These protections will be interpreted liberally in favor of medical marijuana patients. These protections can be removed if an employer can show one of the following. First, that the use of medical cannabis represents a real threat of harm or danger to people or property. Second, its use interferes with the user's performance and essential job functions. Third, its use exposes the employer to the loss of any license, permit, or certification related to any federal law, regulation, program, or fund. Or fourth, the user ingests or possesses medical marijuana in the workplace and or during work hours without the written authorization from that employer. Let's move on to marijuana testing. Philadelphia's ban on pre-employment marijuana drug testing goes into effect on January 1st, 2022. Employers and other employment-related parties cannot require an applicant to submit to marijuana testing as a condition of employment. There are some exceptions to the ban. Certain positions are exempt, including law enforcement, those that require a commercial driver's license, those involving children, medical patients, disabled or other vulnerable parties, and positions where the employee could significantly impact the health or safety of other employees or the public. Another exception could apply if a law requires that the employer drug test applicants due to safety or security concerns, or if a federal contract or financial assistance requires drug testing. Finally, an applicant can be required to take a marijuana drug test if the potential employer is subject to a collective bargaining agreement that specifically addresses that topic. Mississippi voters had approved medical marijuana in the November 2020 election, but the state Supreme Court ruled in May that Initiative 65 is void due to an issue of numbers. Under the law, no more than 1/5 of the total signatures to place an initiative on a ballot could come from any one congressional district, which was broken here. While the court said that it is mathematically impossible to meet this standard, it was required to avoid Initiative 65. At this point, Mississippi medical marijuana can be legalized in only one of two ways. First, through legislation, or second, by amending the broken initiative clause in the Mississippi Constitution. At that time, a new statewide vote would be needed to legalize medical marijuana in the state. We do have an update from Mississippi since our last webinar. The Mississippi legislature agreed to a draft bill for medical marijuana, currently titled the Mississippi Medical Cannabis Act. The draft is almost 150 pages, and I will highlight just a few parts. It will permit the smoking of medical cannabis. In order to use medical cannabis, an individual must be diagnosed by a physician as having a debilitating medical condition, receive written certification of that diagnosis, and have been issued an ID card from the Mississippi Department of Health. 6-month follow-up visits are required in order to evaluate treatment if the users wish to continue usage. The draft bill includes several limitations as to what the act cannot do. For example, an employer is not required to permit, accommodate, or allow medical use of cannabis or modify working conditions to accommodate that use. Employers are also not prohibited from hiring, discharging, disciplining, or taking another employment action based on that individual's use of medical cannabis. Drug testing policies are not prohibited or limited, and the Act does not interfere with any federal requirements, such as DOT. The Act also would not allow an employee to take adverse employment action against an employer due to an employment action tied to that employee's use of medical cannabis. In May 2021, Alabama legalized marijuana for medical purposes. Senate Bill 46, known as the Darren Wesley Otto Hall Compassionate Act, became effective on May 17, 2021. It legalized the use of medical marijuana for 16 medical conditions or categories of conditions. The interesting part about this law is that it specifies how medical marijuana can be used. For example, a patient cannot smoke, vape, or consume edibles, but they are permitted to use capsules, tincture, patches, nebulizer, or oil. The law doesn't impact employers too much. Alabama employers can still maintain drug testing and drug-free workplace policies and can take adverse employment action against applicants and employees who use medical marijuana. They can also require employees to notify them if they possess a medical marijuana card. Employers are not required to accommodate medical marijuana use, though. Alabama does warn potential medical marijuana users of employment risks as part of the consent process. Specifically, certifying physicians must proactively inform patients that their use of marijuana could result in termination of employment. Virginia passed 2 bills that provide protections for medical marijuana users, both of which became effective on July 1st. Under HB 2312, employers cannot take adverse employment action against employees for lawful use of medicinal marijuana. However, employers are not required to allow on-duty marijuana use or impairment. HB 1862 specifically provides protections for users of cannabis oil. Employers cannot take adverse employment action against employees who legally use cannabis oil, generally shown through a valid written certificate from a physician. However, an employer can act if the employee is impaired at work or if not required to violate federal law or risk federal contracts or funding. So there are some exceptions. Connecticut legalized recreational marijuana by passing Senate Bill 1201, which became effective on July 1st. Adults who are 21 and over can possess or consume up to 1.5 ounces of cannabis and can have up to 5 ounces in a locked container at home or in the trunk or locked glove box of a vehicle. Home cultivation will be permitted, starting first with medical marijuana patients and then for recreational users. While recreational marijuana is legal now in Connecticut, retail sales are not expected to begin until next summer. Employers should also be aware that the law will automatically erase criminal records for possession of up to 4 ounces of marijuana. New Jersey also legalized recreational marijuana under a law known as CREMA, which was signed on February 22nd. Except for non-employment provisions, the law became effective upon signature. Employment-related provisions became effective on August 21st. We'll first review the non-employment provisions. Recreational cannabis is legalized for adults who are at least 21 years old. New Jersey has also decriminalized some marijuana offenses, including the possession of small amounts of marijuana or hashish, and has removed marijuana from its previous designation as a Schedule I controlled substance. Those with marijuana-related offenses are able to vacate offenses that occurred before the law went into effect. Also be aware that two other related bills were passed. A 1897 reforms criminal and civil penalties for marijuana and hashish offenses. A 5342, on the other hand, focuses on marijuana penalties for individuals who are younger than 21. CREMA provides protections for applicants and employees. Employers cannot refuse to hire or employ any person solely because that person uses or does not use marijuana for recreational purposes. It also prevents employers from discharging employees who use marijuana recreationally. Normally, these types of laws allow exceptions for certain types of positions, including safety-sensitive positions, but CREMA does not. However, employers can still maintain drug and alcohol-free workplace policies. Employers can also prohibit the use or possession of marijuana or being under the influence at work or during work hours. Federal contractors are allowed to update their policies consistent with federal law. CREMA does outline specific drug testing requirements that an employer must follow in order to take action against an employee who is under the influence at work or during work hours. First, the employer must use scientifically valid methods for testing. Second, a certified workplace impairment expert must physically evaluate the employee and determine that he or she is under the influence of marijuana. These restrictions apply to marijuana drug testing at any time, from pre-employment to random testing. On August 19, 2021, the New Jersey Cannabis Regulatory Commission issued the Personal Use Cannabis Rules. While these rules didn't provide any clarifications on employment provisions in CREMA, they do provide some information. I mentioned a little bit earlier that there's more complicated drug testing requirements, including a physical exam conducted by a certified workplace impairment recognition expert, also known as a WIRE. This requirement is currently waived until the Commission develops certification standards for WIREs. This means that currently employers are not required to conduct a physical exam, and there's no current timeline provided for when that requirement could go into effect. New Mexico's governor signed two bills into law in April. The Cannabis Regulation Act, or House Bill 2, allows the use of recreational marijuana by adults aged 21 and older. The rights of cannabis users depends whether they're in a private setting or a public setting. I'm not going to go into the differences today, but just wanted you to be aware. The sale of marijuana will begin in April 2022, and other provisions went into effect on June 29th. As you can see on the screen, employers do have some impacts. They can have drug-free workplaces, and they may prohibit or take adverse employment action for impairment or possession at work. There's a zero tolerance program that's permitted for employees, but applicants are not specifically addressed. There's also a related bill that's going to allow the expungement of certain Criminal Records Act. So you may start seeing that marijuana offenses have been expunged. New York legalized recreational marijuana on March 31st, 2021. Approving the sale and use of recreational marijuana for adults 21 and older. Retail sales aren't likely to start for next year, but marijuana is currently already legal. It also excluded an expansion of the medical marijuana program. Before we get into how the law impacts employers, I wanted to mention criminal justice reform and record expungement. The state will implement reduced penalties for possession and sale. And it also creates automatic expungement or resentencing for anyone with previous marijuana convictions that would now be legal. Employers in New York already know that they cannot discriminate against employers for their lawful off-duty activities. Lawful marijuana use is now included. There are exceptions. An employer is allowed to take action if required by state or federal law and can act if an employee is impaired by marijuana use. They are also not required to violate federal law or risk losing a federal contract or funding. To an extent, New York employers can maintain drug-free workplace programs. However, it can be complicated because employers cannot discipline an employee for lawful cannabis use before starting work that day, but can take action if the employee is impaired at work. More recently, the New York Department of Labor issued guidance on the Marijuana Regulation and Taxation Act. The guidance and its accompanying frequently asked questions similarly state what I just covered, but let's go a little deeper in a couple of areas. First, what can an employer do? An employer could take action against an employee who, while working, shows specific articulable symptoms of marijuana impairment. The impairment must decrease the employee's performance of duties or must interfere with the employer's obligation to provide a safe and healthy workplace. It doesn't define specific articulable symptoms of impairment, but it does specify that the smell of marijuana on its own is not enough to justify employment action. The employer can also ban the possession of marijuana at work, including company vehicles during non-work hours, and employees cannot use medical marijuana off-site during lunch break, even if they're off-site. So drug testing for cannabis is generally prohibited in New York State. The guidance specifically states that a positive marijuana test cannot be used by an employer as proof of impairment because currently no test for current marijuana impairment exists. An employer may be tempted to argue that they can test for marijuana because it is illegal under federal law. However, the guidance prohibits such testing. The marijuana law does permit an employer to screen for marijuana if federal or state law requires drug testing or makes it a mandatory requirement of the position. Virginia now allows recreational marijuana use, which became effective on July 1st. Under HB 2312, adults who are 21 and older can use marijuana, possess up to 1 ounce of marijuana, and grow up to 4 plants at home. Virginia does have up until 2024 to start retail sales, so it's going to take a bit. There are some restrictions for adult users. They can possess marijuana in public, but they cannot use it in public places. It's still illegal to drive under the influence of marijuana for both the driver and passengers. As for employers, the law does not provide specific protections. Employers should be aware that the law includes an expungement program where eligible offenses will be automatically expunged by July 1st, 2026. We're going to wrap up our talk about cannabis with a quick Amazon case study. I found it very interesting. In June 2021, Amazon updated its marijuana policy, where they're excluding marijuana from pre-employment drug screening programs for non-regulated positions. In fact, they took it a step further and they actually reinstated employment eligibility for employees and applicants who were terminated or not hired due to positive results. Per Amazon, their reasoning is that it's difficult to manage a nationwide marijuana testing program as marijuana legalization increases across the country. Marijuana convictions and marijuana use tends to have a disproportionate impact on minorities, and it also expands their applicant pool by not testing for marijuana. So, what now? The treatment of marijuana can be a daunting topic, and we have some best practices for employers. First, make sure you review new laws and revisit existing ones with in-house or outside legal counsel. They can assist with breaking down the laws and determining your rights and obligations. The second step is to make sure you document everything. Have clear policies in place that show where your company stands. Keep in mind, marijuana is still legal on the federal level, which could impact your workplace policies as well. Also be aware that, depending on state law, you may have accommodation obligations under a state's disability law. You should also work with legal counsel to determine if you are permitted to drug test and whether there's any limitations on that testing. What can we expect in the world of background screening and employment laws we head into 2022? Honestly, I always say more of the same, and that has been very true over the past few years. We'll likely see additional ban-the-box laws and expungement laws may also increase, especially related to marijuana legalization and decriminalization. Privacy is going to continue to be a critical topic. We should also see how employers are impacted due to marijuana legalization. As for identifier redaction, we hope to see an update in California, and I mentioned earlier that we do have an update in Michigan, which I will cover in a blog post very soon. As New York City employers use a bifurcated screening process, we hope for a smooth transition for employers and applicants and employees. AccuSource will keep you posted of industry trends and hot topics as we learn of them. AccuSource is always happy to recommend best practices. First, carefully review your background and drug screening procedures, as well as hiring practices to ensure you're compliant with any new laws. Review employment applications to make sure you're not seeking information about criminal history. While you may not be based in a ban-the-box jurisdiction, you should be aware that many jurisdictions do have restrictions. We didn't discuss salary history bans today, but be aware of any that exist in your area so that way you can comply with them as needed. Due to the increase in expungement laws, be aware that you may not receive records that you previously did when rescreening employees. Watch new privacy laws closely and determine if you need to come into compliance. Remember to keep a close eye on marijuana legalization and decriminalization of both marijuana and harder drugs. If you have applicants or employees in New York City, come into compliance with the Fair Chance Act as quickly as possible if you've not already done so. We recommend reviewing any of these areas with your in-house or outside legal counsel to determine how the changes affect your background and drug screening programs. We've now reached the end of this presentation, and I will now answer questions that we received.
Thank you, Jennifer. Now we'll dedicate the remainder of the webinar to addressing attendee questions. If you have had not a chance to ask a question via our chat box, please feel free to do so now.
Thank you, Randy. The first question that we have for you, Jennifer, is you had discussed expungement laws. How will those affect our background checks?
So the biggest impact will be if you rescreen employees, such as an annual background check. It could also come up if you have the same applicant applying again, and if they've had an expungement, that previous record that you saw might not come up anymore. So just be aware of that.
All right, and we have time for just about one more question. So how do you recommend that we approach changing marijuana laws?
It depends on your specific circumstances and the approach that your company wants to take towards marijuana. As I discussed earlier, Amazon decided to remove marijuana from certain testing panels. Following Amazon's lead could open up your applicant pool a lot. That being said, your decision should involve a risk-benefit analysis to see whether the benefit of removing marijuana from your testing panel outweighs any risk of doing so. Be very aware if you're in any of the jurisdictions that have banned pre-hire marijuana testing, or you have employees elsewhere, you may want to consider removing marijuana from pre-employment testing across the board. That could simplify your process, and it creates a more uniform drug test policy. As always, I highly recommend that you review with your legal counsel to see how the laws apply to your specific situation.
Thank you, Jennifer, for facilitating this informative webinar, and special thanks to our attendees for joining us today. If you have any additional questions, please contact us at marketing@accusource-online.com. On behalf of the AccuSource team, we wish you all an enjoyable day.